My name is Justin Myers and I am a Utah bankruptcy attorney. Today we are going to be discussing exempt property in Chapter 7 bankruptcy cases. This and other topics can be read about in a book I wrote entitled Filing Bankruptcy in Utah. You can order a copy of this book from utahbankruptcybook.com. That's utahbankruptcybook.com. You can also call my office at 801-308-8200, 801-308-8200, and set up a free initial consultation to meet with me to discuss your options. Exempt property is property that is exempted from the bankruptcy estate. This is property that the debtors can keep and that a Chapter 7 trustee cannot take from them. Exemptions are allowed in order to help people get a fresh start. When debtors properly claim their exemptions, they are usually allowed to keep their basic furniture, clothing, and other necessities. Also, depending on the value, debtors can often keep their vehicles and homes in their Chapter 7 bankruptcy cases. If the value of the property exceeds the value of the exemption, the Chapter 7 trustee could take and sell the property for the benefit of the debtor's creditors. If the trustee sells any of the debtor's property before any money is dispersed to creditors, the trustee must pay the debtor the dollar amount of the debtor's rightfully claimed exemption. This means that if a debtor owns a car that is worth $6,000 and the debtor claims an exemption in the car in the maximum amount of $3,000, which is the maximum amount for Utah, then the Chapter 7 trustee might take and sell the vehicle. If the trustee does sell the car, the trustee must first pay an auctioneer to sell it, and then the next $3,000 will be used to pay the debtor. Now, if there was a loan on the vehicle, the trustee would pay the loan off before the trustee paid the debtor out his exemption amount, and before any money was distributed to creditors. As a rule of thumb, trustees only sell property if it will net them enough money to pay a reasonable amount to creditors. If a trustee only nets $100 from the transaction, the trustee might not take the property for sale. For homes and vehicles, the court requires the debtor's name be titled on the property in order for an exemption to be claimed. For instance, if a couple owns two cars and they are both titled only in the husband's name, the husband will be the only one who can take advantage of the vehicle exemption, and the wife will be unable to claim any vehicle exemption at all. Exemption amounts dramatically vary from state to state. To illustrate the difference, consider the homestead exemption in two different states. The homestead exemption is the amount a debtor can claim in the debtor's home. The home usually must be the debtor's primary residence. The state of Utah has a $30,000 primary residence homestead exemption per person. The state of Florida has an unlimited homestead exemption. This means that if a single debtor in Utah owns a house worth $200,000 and has a mortgage lien against the home in the amount of $120,000, then the Chapter 7 trustee would probably sell the house. After paying a realtor 6% or $12,000, after paying off the mortgage of $120,000, and paying the debtor's properly claimed exemption amount of $30,000, the trustee would still net approximately $38,000, and that could be used to pay the debtor's creditors. In Florida, if a debtor owns a house worth $1 million and has no mortgage against it, the debtor can keep the entire home with all of the equity in it, and the trustee could not sell the house. As this example illustrates, great inequalities in exemptions exist between the different states. Unfortunately, in Utah, the exemption laws are not very favorable for the debtors, meaning that they're pretty low amounts. Debtors must use the exemption laws and rules for the state where the debtor lived exactly 2 years before the bankruptcy case was filed. This means for a bankruptcy case filed June 30th, 2013, the debtor will use the exemption laws in the state where the debtor lived on June 30th, 2011. This can get rather tricky because some states only allow a debtor to claim the state's exemptions if the debtor is currently living in that state. If this is the case for the debtor, then the debtor may be entitled to claim federal bankruptcy exemptions. Before the debtor files the bankruptcy case, it is important to understand exactly what the debtor's state exemption rules are and which exemption laws the debtor is required to use. This way, the debtor will not be surprised if or when the Chapter 7 trustee demands the surrender of certain property for the trustee to sell. For this reason alone, it is very important to consult a bankruptcy attorney who can help explain exemption laws.